IGN and interlock device requirements in NY. A DWI conviction in New York doesn't just mean fines and license trouble. It can mean a breathalyzer wired directly into your car's ignition system, controlling whether you can even start the engine. Under New York law, an ignition interlock device is a breath testing unit installed in a vehicle that prevents the engine from starting if the driver's blood alcohol content exceeds a set threshold at the time of the attempt. The device also requires what are called rolling retests, meaning the driver must blow into the unit at random intervals while the vehicle is already moving and the engine is running. Every start attempt, every BAC reading, and every minute the vehicle is driven is recorded and monitored throughout the entire court-ordered installation period. In New York, this is not a discretionary add-on. A judge must impose the ignition interlock device as a mandatory condition of either probation or a conditional discharge following a qualifying DWI conviction. Thanks to Leandra's law, signed in November 2009 in honor of 11-year-old Leandra Rosado, who was killed by an intoxicated driver, anyone sentenced for DWI on or after August 15, 2010, must have the device installed on any vehicle they own or operate. The mandatory requirement applies to first offense DWI with a BAC of 0.08 or higher, aggravated DWI at 0.18 or above, aggravated DWI with a child passenger, and felony-level repeat DWI offenses under VTL Sections 1193 and 1198. One important distinction worth understanding is that a standard first-time DWAI by alcohol under VTL Section 1192(1) is treated as a traffic infraction rather than a DWI conviction and does not automatically trigger the ignition interlock mandate. A limited exemption exists for employer-owned vehicles, but only when the employer knows about the restriction, provides written permission for business driving, and the required documentation is submitted to the court and the probation department. Driving a spouse's vehicle or any non-equipped car without a valid exception does not avoid the obligation and can result in a separate criminal charge under VTL Section 1198(9). New York generally imposes a 12-month IID restriction after a DWI conviction, though the requirement may be satisfied after proof of at least 6 months of proper installation and maintenance, unless the court ordered a longer period. Missed service visits, failed breath tests, tampering concerns, or driving a non-equipped vehicle can all constitute compliance violations that lead to additional court action or even extend the restriction period significantly. Suffolk County DWI lawyer Jason Bassett will review all vehicle use restrictions, evaluate any available exceptions, and examine monitoring records to advise on options if a violation threatens to extend the interlock condition or violate probation. As a dedicated criminal defense attorney who understands the full scope of interlock-related charges, Jason Bassett stands ready to guide clients through every obligation New York's DWI sentencing law imposes. Contact the law offices of Jason Bassett, PC, located at 320 Carlton Avenue, 4200, Central Islip, New York 11722, United States, by calling 631-259-6060 to schedule your consultation and get the experienced guidance your case demands.